Hello, Blake Lively here.
Colleen Hoover.
And It Ends With Us is in theaters now, so grab your friends, wear your florals, and head out to see it.
Hey everyone, Justin Baldoni here, and I just wanted to say thank you. Thank you so much to all of you who have supported us from the very beginning, from when we optioned the book and announced it. How this has been a passion project and something that has been so near and dear to my heart and so many, and it wouldn't happen without you.
We have breaking news from the Southern District of New York. Yes, we do. That is what? What, besties? Judge Louis Lyman has issued a new ruling, and it will reshape the legal battle involving Miss Lively and her husband, Ryan Reynolds, their company, Vanzan Inc., and former Baldoni publicist, Stephanie Jones. Why? Why does this reshape that? Because Judge Lyman issued a ruling in the counterclaims Jen Abel filed against Stephanie Jones. While the judge did dismiss several federal hacking claims, two of the most serious allegations survived, and they could be the ones that cause the greatest damage because they go directly to the heart of the story. What's the story? It's how did Jen Abel's phone data get in the hands of Blake Lively and how it was accessed without authorization, how she was then cut off from her accounts, and how the data then flowed to Vanzan in a sham litigation and ended up in a lawsuit against Justin Baldoni and her by Blake Lively. We're going to walk through what the wins were for Jen Abel and even for Wayfair and what these impacts mean for Stephanie Jones and Blake Lively. Because for Jones, this actually could involve criminal exposure now, because allowing a California penal code that also has a criminal code attached to it could have prosecutors in California have their eyes opened. So let's talk first about what she won in this motion to dismiss. Judge Lyman dismissed the federal statutes, the Computer Fraud and Abuse Act, the Store Communications Act, and the Wiretap Act. Those fell short on the technical pleading requirements, but she still walked away with two powerful claims: the California Penal Code, Section 502, and conversion. With the federal claims, she did get an opportunity to amend those, and we'll get to those in the next part of this video. But what is the California Penal Code and what does it mean? So under California Penal Code 502, California's computer crime statute, it makes it unlawful to knowingly, without permission, access someone else's data. Importantly, the law does not require that the data be confidential, sensitive, or even business related. It simply requires that the access was knowing and unauthorized. And if you enter someone's digital account, phone, or storage without permission, you are in violation. This doesn't even matter if Stephanie Jones claims it was her work phone. It's that the data was Abel's. Abel alleged that Stephanie did that. She knowingly accessed her phone data, including information stored on her iCloud. The judge ruled that Abel's pleadings were sufficient, meaning she made out a plausible case that unauthorized access occurred. In his order, the judge Lyman opined, Abel has adequately alleged knowledge on behalf of the Jones parties that their access to her phone was without permission. She alleges that she provided her passcode for only the limited purpose of facilitating the transfer of her phone number, and that afterwards the Jones party could access her phone only because they retained access to her iCloud account without her permission. Furthermore, she alleges that because they had the iCloud in hand, the Jones parties could bypass the password protection that would otherwise bar their access. Those allegations must be read together with others in her counterclaim. For example, that using a personal phone at a public relation job is common practice, and that Jones Works had no policies that gave it the right to monitor her phone, and that her willingness to port her personal phone number into her work phone was predicated on a reasonable expectation that she would retain sole and exclusive access to the contents and her private data and accounts. Jen Abel had no reason to believe that Jones Works would attempt to access such data, or she would not have turned the device over without making prior arrangements to secure it. Despite lacking Abel's consent to access, review, or disseminate these communications, Jones and Jones Works were able to do so. Taken all together, these allegations plausibly give rise to entitlement to relief. Jones said that it didn't matter that she accessed the phone because it was a work phone. The judge here is saying, I'm going to take as fact what she said, that you didn't have a policy that gave you the right to monitor her phone. You made an agreement with her that she would port her personal phone number into her work phone, and it was predicated on the expectation that she would retain the exclusive access to the contents of it, and that she handed it over because she had no reason to believe that you would go into that data afterwards, and she would never have turned over the device without making prior arrangements to secure it had she known. The heart of this is that this claim goes to the matter of this data that she took is what actually ended up in the hands of Blake Lively. And this data is what ended up in the lawsuit against Justin Baldoni and Jen Abel and Tag to make her lawsuit. This cuts at the actual evidence in the case and could ultimately result in serious consequences for Blake Lively. When it comes to conversion is an old tort, and it's often described as civil theft. It occurs when someone takes or intervenes with another person's property and deprives them of using it. Abel alleged that she was cut off from her phone accounts and her phone number and her two-factor authentication codes and her ability to access personal and professional accounts. She spent time and money recovering access. The judge held that those allegations plausibly show damages, and therefore the claim survives. So when you combine these two together, she stole the phone, which is the conversion. She stole the phone number, which is tied to all the data, the text messages and all of it. And then she accessed it unauthorized. She refused to hand over the phone number after she was given the phone. Remember, she gave the passcode only so that the phone could get ported to a new phone. So together, one establishes the wrongful act of illegal access to her phone and data. The other establishes the real world harm of being locked out, deprived, and forced to fight to regain control. What's significant here is that one, in this case, when it comes to Jen Abel, he ruled that California law applies to Abel because the acts occurred in California. This could also end up proving difficult for Blake if he's going to be this literal, because the act of her phone getting taken and accessed happened in California, right? But the Blake Lively's case, the act she claims for sexual harassment did not happen in California, but she wants California law. This could be a we can look to the future as how he might rule for Blake Lively. Abel doesn't need federal hacking laws if she has Section 502 and conversion. Those two claims let her go into discovery, let her go to trial, and it forces Blake's side to answer those questions of how did the data move from her phone to Stephanie Jones to Vanzan and then into Blake's court filing. And if she can prove that chain of custody, it can completely impact Blake's entire lawsuit against Baldoni, Abel, Tag, and everyone else. Now, for the federal claims, he dismissed them with an option to amend the complaint. So he dismissed the Stored Communications Act because this law protects electronic communications held in storage by providers like iCloud, Gmail, or WhatsApp. He dismissed the claims because she didn't allege clearly that her data was accessed from the storage as opposed to just pulled off of her phone. So this is where if she has like a screenshot that she knows was only stored in her photos, like if she has all of her photos set to go to iCloud and she had that setting on and she knows that the screenshot was pulled from iCloud, a new amendment would have to show what actually she knows was pulled from the iCloud versus what was just pulled off the data on the phone. If she can plead that she accessed her iCloud and shared screenshots from there, it would satisfy this claim. And that allegation itself would be critical and should be one of the most important aspects in this amendment. So she needs to be able to prove and show proof and provide examples to the court of what exactly did she take from your iCloud? What exactly did she take from your Gmail? Because remember, some of it can be stored on the phone itself, right? And if she took it directly from the phone, he's saying the Stored Communication Act doesn't apply. With the Wiretap Act, it requires proof of an inception in real time while the communication is in transit. And she doesn't actually show contemporaneous interception. So to fix that claim, she needs to allege that her communications were monitored live or captured in real time, not just after the fact. And if she has evidence that they were accessed as they came through iCloud, that could revive the claim. For the invasion of privacy claim under California law, the judge said that the complaint lacked detail about why the intrusion was highly offensive. The amendment should spell out what the humiliation was, the severity of having her personal phone content exposed, and how it violated Abel's most intimate expectation of privacy. The narrative should emphasize that this was not just a technical breach, but a deeply invasive act. And one of the issues he noted in his actual motion, he says that she argues in her brief responding to the motion to dismiss that the Jones party selectively disclosed her private communications to create a misleading impression of Abel's involvement in a supposed smear campaign, which Jones' work knew was false. But the judge says that the allegations aren't in the counterclaim doesn't contain those allegations. The closest they come to is in paragraph 93, in which she alleges that the messages revealed were modified with slicing, dicing, and cherry picking, massaging, and in some cases, outright alteration. Absent any non-conclusory allegation as to the false light cast on Abel, she cannot state a claim. So she would be in the state of false light. She needs to be able to show what messages were altered, what ones were made publicly that were private, how they were altered to mislead the public. But the way it's currently cited, it doesn't provide enough specifics. So she needs concrete proof. With the intentional and negligent infliction of emotional stress, that the judge said they were too vague. So Abel needs to show how the lockout and then the misuse of her phone data caused severe distress, anxiety, or harm, and why the conduct was outrageous, which may include and describe ongoing stress, sleepless nights, or reputational harm she endured. Right now, those two claims were very vague, and she didn't get into the details of what she actually experienced. So in order to properly plead, she again needs to go into more specifics. The promissory fraud was equally vague. And so the promissory fraud was that Jen Abel handed over the phone with the promise that she was giving access to the phone only so that the phone could be ported, and that Miss Abel and that Stephanie Jones promised. The promissory fraud is premised on the fact that she was claiming that Jones Works promised to port her phone number back to her, and that she was promised that she would be able to get her phone number back, and that she was handing over her passcode only for that purpose. So she needs to specify the fraud, which is the clear promise, the reliance, and the intent. So she must specify who made the promise, when the promise was made, and who she relied on, and how she relied on it to her detriment. Without those details, the claim will be hard to save. It needs sharper detail, especially on the iCloud access for the Stored Communications Acts, for the wiretap, and then for the privacy and reputation and distress claims. It was basically just not enough examples, not enough proof. But because she has the opportunity to amend those claims, it's not dead. If they can get better on those and more detailed, it could come back. So what does this mean for Stephanie Jones? Well, it means that two pretty significant claims are moving forward. It means that on the hacking allegations move forward under the 502. It's basically that Jones, who was once Justin Baldoni's publicist, she is the person that is alleged to actually have accessed her phone and data, Abel's phone and data, and that the surviving 502 claim puts her front and center. It says that she illegally entered Jen Abel's phone or accounts. The conversion claim ties Jones directly to the harm, the lockouts, the loss of control, and the costs that Abel incurred. And because it doesn't matter if this was private or public information or whether it was business or personal, and the judge ruled that there was no expectation that Jones had the right to do this, the discovery that Abel obtains here is going to allow her to get communications, emails, and digital footprints that were left by Stephanie Jones. And where this actually gets risky for Jones is that Section 502 is not only a civil law, but it's also criminal. So the civil case and the evidence uncovered in the civil case could also expose Jones to possible criminal scrutiny in California if prosecutors decided to take interest. So if she gets discovery that shows criminal intent and criminal actions being taken, Jen could turn that over to law enforcement. So Jones is now in a very precarious situation because if she proves her claims, Jones is the one who illegally accessed the data, and she's the one who set in motion everything that followed. So what does this then mean for Blake Lively and Vanzan? It means that Abel's central allegation is that Jones accessed the phone and the data, but the stolen material didn't stop there. It was then funneled through Vanzan, Blake and Ryan's company. And remember, Abel says that the access started on August 21st because a phone call was made to Melissa Nathan that said, I saw the text messages, you're going to get sued. Okay. So her allegation is that they stole the data and then to bypass the contracts for Wayfair for Jones breaching the contract of releasing private information about her clients to someone else, they used the Vanzan, and the Vanzan was also used to funnel the fact that she accessed the phone without authorization. So then in October of 24, Blake's company, Shell Company, files a Doe lawsuit in New York. The case issues subpoenas, and according to Abel, those subpoenas were a sham and a cover to design to give legal legitimacy to data that had been stolen. The Lyman has already allowed Abel to obtain Vanzan's internal emails and communications, and that means discovery is going to probe exactly how the chain worked. Did Jones send screenshots to Vanzan? Did Vanzan's lawyers know that the data had been obtained unlawfully? Did Blake's team knowingly build their filings on stolen information? If Abel proves that chain, that Abel's phone to Jones to Vanzan to Blake, then the implications are massive. It would mean that Jones handed stolen data to Blake, Blake's team built their case on tainted evidence, and then the court could exclude the evidence. Abel then could recover punitive damages against Stephanie Jones under 502, and the judge could issue sanctions if it is shown that Blake's side knew the origin of the data and still used it. This ruling keeps the door wide open for Abel to prove that Vanzan was nothing more than a sham lawsuit designed to launder stolen data into Blake's case. And because the judge has preserved Section 502 and conversions, they're not going to go away. So even if she does an amendment, he's going to keep those in even on the next amendment. So it's assumed that she'll amend her complaint, which will be due on October 31st. After she amends her complaint, another motion to dismiss will likely be issued. Those are always going to be able to move through. He has already said she properly stated them. He's not going to dismiss another amended complaint. And here's how it even flips Vanzan on its head, because even if the Vanzan subpoena was quote unquote legal from Blake's view, it was not legal from Stephanie Jones' view, because if 502 has survived, because it has, and if she's proves this at the end of if she's able to prove this to a jury and at trial, it's that Stephanie Jones never had authorization to access her phone, period. Even the data, not just the iCloud, but the data itself. And a subpoena can only compel a person or a company to hand over information they have a lawful right to possess or control. So if Jones' possession of her data was the result of illegal, unauthorized access under 502, she never had the lawful right to it. That means any subpoena directed at Jones or material she provided in response is tainted because it compels production of unlawfully obtained property. What this can prove is that the subpoena itself was illegitimate because it targeted stolen material. The Doe lawsuit was used as a laundering mechanism to make illegal access look like formal discovery, and that any evidence obtained through that process should be excluded, and the sham nature of the Doe case is confirmed. It directly ties Blake and Ryan to use of illegally obtained data if it's proven. It undermines their entire evidentiary base because what was funneled in through Jones and Vanzan is tainted from the start. And if her legal team knew it occurred, and this is how the data was sourced, it raises the stakes for sanctions and punitive damages. It could also mean that she could add Blake Lively to the lawsuit because Penal Code 502 allows the liability to reach any person who knowingly aids in assists, solicits, or benefits from unauthorized access. So if she can prove that Jones unlawfully accessed the data and that Blake and Vanzan then used that data knowing its origin, she could be directly liable herself under 502, Blake. And the fact that the Vanzan sham strengthens the case. If Vanzan was a sham mechanism to launder the stolen data into litigation, and if her discovery can show that Blake was aware that this came from the phone, it would actually justify Abel naming Blake and Vanzan in a civil liability. And you have to remember, they have already taken the deposition of Vanzan at this point. They have emails and communications between Vanzan and Jones now. So an amendment could also include the addition of Blake or Vanzan to the lawsuit. So expect some changes coming down the pipe. But this impacts both the civil case for Blake's case against Baldoni and Abel and Tag, and it also puts them, it puts Blake and Stephanie on notice that this is going to move forward. Your evidence could very well be tainted, and now you've opened yourself up to criminal exposure if prosecutors in the state of California want to pursue this. Pretty wild, huh? And some of you are going to be disappointed that he threw out some of the federal case claims. Again, if she can plead these and they have more evidence and they have more examples, some of them might be able to stick. Those were always a long shot. But the kicker here is that the 502 is what's the big one, and it's moving forward. So this is a good moment for Jen. It strengthens the resolve that her data was stolen and used, weaponized against her for the lawsuit for Blake. And it really undermines Blake's attorneys claiming Vanzan was done totally normal and it was her right to do that. And their denials that they know anything about how the phone was obtained likely is completely baseless because Jen's already said she has evidence that they called on the very day her phone was taken, that they had seen her texts. So what are your thoughts? Are you surprised that this ruling favored Jen? And what do you think her amendment will look like? And how do you think Blake and Ryan are going to try to spin this in the media? Tell me your thoughts in the comments below. Please make sure to give this video a thumbs up. Make sure to subscribe to my channel if you haven't subscribed and click the bell so you never miss a video. Thanks so much for watching. Bye, besties.